All right, everyone. So we're going to go ahead and get started now. So again, thank you for joining us all today. Again, the title of this webinar is New Legal Challenges to the ACA, Understanding the Current Landscape. Just a little housekeeping before we get going. We are going to be taking breaks after each speaker so that you can ask questions. You can use the chat function on the side of your webinar screen, and that's how, and the question function. That's how we'll be able to see any questions that you have. So feel free to type in a question anytime. And during the Q&A breaks, the moderators will go ahead and read those that have been submitted, and we will answer your questions for you. If you are having any audio or webinar trouble, please do go to HIV Health Reform /webinar for troubleshooting help. If you can't hear the audio, you can also use your telephone to click on the audio tab, and then you dial in the telephone number and the access code and the PIN that appears, and that will help you hear if you're not able to hear through your computer. And once again, if you'd like to download the slides to follow along on your home computer or your work computer, please go to hivhealthreform.org. The slides are available in a featured blog post at the top. All right, and today, here's our agenda. We will be hearing from Robert Greenwald. We'll also be hearing from Katerina and Spencer as well. So we will now be turning it over so Robert can make those introductions.
Good morning, everyone, or for everyone not on the East Coast, and good afternoon for everyone on the East Coast. As Sarah said, my name is Robert Greenwald. I'm a clinical professor of law at Harvard Law School and the director of the law school's Center for Health Law and Policy Innovation. Today I have the pleasure of introducing you all to our webinar on the latest challenges to the Affordable Care Act. And as important, I have the opportunity to introduce two of our summer law clerks who represent the best and brightest of our law students, up-and-coming lawyers who are committed to working to promote health law and policy reforms. This afternoon, we're first going to hear from Katerina Souliopoulos, who is going to describe the United States Supreme Court ruling in Hobby Lobby versus Burwell. In this case, the court issued its decision on the last day of this year's Supreme Court session, June 30th, with Justice Alito writing the opinion for the majority of the justices. As most of you probably know, it is a very disappointing decision. One more decision, I might add, in a series of decisions that reflect a war on women, and in particular, a war on women's health, with in this case the court finding that closely held corporations, like the family business Hobby Lobby, could not be required to provide no-cost access to contraception to its employees through their health insurance plan as required by the Affordable Care Act. As you will hear from Nina, who will explain the court's rationale, the court found that mandating coverage of free contraception violates the Religious Freedom Restoration Act. Next, we will hear from Spencer Benj, who will describe two conflicting U.S. Courts of Appeals decisions that were issued on the same day in July. In one of the decisions, the King decision, the appeals court found that the IRS rule that holds that individuals purchasing private health insurance in both federal and state-run exchanges are eligible for tax subsidies, and that is a valid interpretation of the Affordable Care Act. In the other decision, the Halbig decision, a different set of appeals court justices in a different circuit or geographic area, on the other hand, found that the proper interpretation of the language in the Affordable Care Act limits subsidies only to those living in states with state-created exchanges or marketplaces. As you will hear from Spencer, the implications of this decision are significant, and while there are now conflicting decisions, if a final decision is ultimately decided the wrong way, it could mean that millions of people who currently have subsidized health insurance living in states that do not have state-run, that do not have state-run marketplaces, could lose their subsidies and tax credits. So lots to talk about in terms of recent Affordable Care Act challenges. But before I turn it over to Nina, I want to take one more minute for what I consider, the editorializing portion of this webinar. First and foremost, I think it is important that we remember that the Affordable Care Act is a battleground issue here in America, and that those who are so vigorously opposing the Affordable Care Act have a big agenda. In terms of so many issues, but today focused on the Affordable Care Act, we must fight back and stay engaged in any way we can in protecting and promoting the rights of our most vulnerable friends and neighbors. And this fight is not just in our courts, it's in our Congress and our state legislatures, as well as in the courts of public opinion. As to health reform, despite all of its challenges, and there are many, the ACA represents a significant step forward in addressing the health insurance needs of millions of Americans, including many people living with HIV and other serious health conditions who, prior to the Affordable Care Act, had no access to either public or private health insurance. We must be strong, and we should be proud. In terms of the Affordable Care Act, despite hundreds of court challenges and an equal number of federal and state efforts to undermine the Affordable Care Act, we have been part of an effort that has successfully ensured that in its first year, over 8 million people are newly enrolled in health coverage through marketplaces, and an additional 4.8 million are newly enrolled in Medicaid. Working together, we must continue to challenge our opponents and work to ensure that the ACA and other health reforms truly work for all people living with HIV and all other Americans. Thank you. I'll now turn it over to Nina, who will be talking about the Hobby Lobby decision. Thank you.
Hi, everyone. So I'll be covering the Hobby Lobby decision, which is the challenge to the Affordable Care Act's contraceptive mandate. And just to begin, I'll start with some background information to provide some context, and then we'll get to the case itself. Next slide. Okay, so background of the ACA's contraceptive mandate. Under the ACA, all organizations have to provide coverage of a specific set of services that were given an A or B rating by the U.S. Preventative Services Task Force, as well as additional services for women that were recommended by the Health Resources and Services Administration. And all of these services have to be without cost sharing, which is a really revolutionary thing about the ACA. And lastly, too, in mandating the contraceptive coverage, the government extended an Equal Employment Opportunity Commission ruling, which stated that employer health plans failing to cover contraceptives violate a Pregnancy Discrimination Act of 1978. So the ACA, I just want to stress that the ACA's contraceptive mandate was adopted under recommendations by Health Resources and Services Administration, as well as Equal Employment Opportunity Commission ruling. And under the ACA right now, we have to cover 20 FDA-approved contraceptives, and these do not include any abortifacient drugs. Next slide. So already existing, there are religious exemptions to the contraceptive mandate. One is for purely religious employers. They're totally exempt from the mandate. And also, nonprofit organizations that have religious purposes, they can certify their conscientious objection to providing contraceptive coverage by requesting an accommodation from their insurer or third-party administrator. And then after they do that, the insurer or third-party administrator must provide the contraceptive coverage to the employees at no cost to the employees, kind of with the rationale that contraceptive coverage saves money by not having to cover pregnancies and such by the insurance companies. So they take those funds that are saved and pour it into covering contraceptives for nonprofit organization employees. And here for the exemptions, I think it's important to note that when the ACA actually worked its way through Congress, the Senate voted against a conscience amendment to the contraceptive mandate. And this conscience amendment would have allowed any employer or insurance provider to deny these services based on its religious beliefs. And I think that's important to note because by voting against this conscience amendment, Congress placed, scientific consensus as well as the personal medical decisions that women make with the guidance of their healthcare providers above other variable beliefs of insurance providers or employers. Next slide. Oh, to give you some background as to the plaintiff, we know there were more than one plaintiff in the Hobby Lobby case, but today I'll be mainly focusing upon the star plaintiff, which was Hobby Lobby Stores Incorporated. So I think something really important to stress here is that the lawyers in this case picked like the absolute perfect plaintiff that they could. For example, Hobby Lobby stores only place Christian music in all of its stores. They begin meetings with prayer, and they're closed on Sunday for worship. And further, Hobby Lobby and also the second plaintiff, Conestoga Wood, they're each what we call closely held corporations. Closely held is really a tax law distinction, and it means that 5 or fewer individuals control the corporation by holding more than 50% of the stock at any time. And many closely held businesses within the U.S. are mom and pop stores. However, as we can see specifically with Hobby Lobby stores, which has over 14,000 employees across the U.S., closely held corporations can be very large corporations as well. And we think that it was very strategic to bring closely held corporations as the plaintiffs because it would be easier for judges and individuals to see these 5 or fewer individuals who are usually family members that are in control and know precisely whose religious beliefs were at stake and kind of sympathize seeing them rather than a large corporation. Next slide. I think another part of what made Hobby Lobby stores such good plaintiffs to begin with was actually what they objected to within the contraceptive mandate. And Hobby Lobby specifically only objected to 4 out of the 20 FDA-approved contraceptives under the ACA. In particular, they objected to only the contraceptives that prevent the implantation of a fertilized egg into the uterus because in their religious beliefs, this was tantamount to abortion. And I think that's very important because they wanted to start with plaintiffs that are only objecting to a few of the contraceptives at hand and not all of them at once. Next slide. So the questions before the court within Hobby Lobby, I wanted to go over this because they mainly relied on the Religious Freedom and Restoration Act of 1993, which we call RFRA. So the questions that the court kind of had to work their way through in deciding the case before us was, do Hobby Lobby stores and other closely held corporations actually have religious exercise protections under RFRA? And if they do, does the contraceptive mandate substantially burden these rights? If yes, does the government have a compelling reason for actually substantially burdening these rights? And then you move on, if yes, is the burden that the government's imposing the least restrictive means of achieving that purpose? So this is the analysis that the court actually engaged in when they went through the Hobby Lobby decision. Next slide. So now we get to the good part, what the court actually found. So the court found that first, closely held for-profit corporations are persons and can bring religious exercise claims under RFRA. The court got there because they took a look at the Dictionary Act and looked up the word person and persons and found that it did technically include corporations. So that means that they applied closely held for-profit corporations as persons under RFRA. And then second, they found that Hobby Lobby and the other plaintiffs did indeed have genuine religious beliefs that were in direct opposition to contraceptives, and that the requirement actually substantially burdens that belief. And the court took for granted, really, that ensuring access to contraceptives for women was a compelling governmental interest, which was very much a silver lining. But in the end, the court determined that there were other less burdensome ways of achieving this purpose of ensuring contraceptive protection, such as the accommodation currently available for nonprofit religious organizations. And I'd like to just point out that this ruling was, within the ruling, Chief Justice Alito stated that corporations cannot use this exemption as a shield for employers who might cloak illegal discrimination as a religious practice. And yet this ruling was in direct opposition to the year 2000 Equal Employment Commission ruling, stating that health plans not covering contraceptives are discriminatory. So that kind of just points out a very clear disconnect and disregard that I think is present in the majority opinion. And I'd also like to point out that 10 medical groups led by the American College of Obstetricians and Gynecologists very much disagree with Hobby Lobby and the court, and they filed an amicus brief stating that there is a scientific distinction between a contraceptive and an abortifacient, and none of the FDA-approved contraceptives covered by the mandate are abortifacient. So it seems that the disconnect and disregard that I just mentioned also applies to science as well. Next slide. The bottom line with the decision, though, there's one silver lining in that the court didn't actually hold that employees do not need to have access to birth control. So I think that's a really important thing to keep in mind. They only really determined that closely held corporations can certify that they have a religious objection and that they can request an accommodation from the mandate, which now in the future will be very exciting to see what the federal government is going to decide what the accommodation will actually be. Many people suspect that it will be very similar to the accommodation that currently exists for some religious nonprofits, but we have yet to see the federal regulations that it will be put out. Next slide. So where do we stand now? What's going on? So right now, the existing accommodation that the Supreme Court actually specifically points to within Hobby Lobby as another alternative method that is less restrictive for the government to impose upon Hobby Lobby. It's actually being challenged right now in the lower courts. Very shortly after the Hobby Lobby decision, the Supreme Court granted an injunction to Wheaton College from complying with the contraceptive mandate until the validity of the religious exemption was analyzed. So, and also we have other organizations stepping forward and claiming that the religious objection form that they must sign and hand to their insurer or third-party administrator entangles the company too much in providing contraception, and so then it violates their First Amendment rights. So what we have right now is the Supreme Court directly relied upon and premised its solution in the decision of the government giving an accommodation similar to the accommodation that exists for religious organizations. Now it's being questioned. So we have yet to see what this is going to turn out. And further, the court maintained that this ruling in Hobby Lobby was a narrow one, but there are actually concerns that this decision may potentially open the door for closely held corporations to challenge other government mandates under religious exercise, because the court didn't limit and narrow at all the types of claims that corporations could bring. They only said that corporations could bring a religious exercise claims under RFRA. Crucially, I think we need to remember that, for the 28 states that actually have laws on the books already that mandate their health plans to have to cover contraceptives, the Hobby Lobby decision won't do very much, but we really worry for the other 22 states that don't have these laws on the books, because for them, Hobby Lobby can significantly impact the healthcare needs of women and their dependents, as well as open a very slippery slope for other vulnerable populations, such as people living with HIV and AIDS. Next slide. So right now, I think it's really important that advocates everywhere really focus on education. It's critical to ensure that all women understand that they still have a right to contraception, and that other critical women's health services, such as routine HIV screening and mammographies and screening for domestic violence, have not been affected by this ruling. Also, it's really important to continue to educate those around us, such as legislators, government officials, and others about the critical importance of access to contraceptives. We need to also continue to fight for the importance of programs like Title X, and also in the near future, as I mentioned, the administration is going to be releasing regulations discussing the potential accommodations, and it'll be really important for all of us advocates to actually go ahead and comment on these regulations. And I think it's very clear to see that all of these decisions that we're going to be talking about today, they do have an impact on kind of the war on women's health, and it's really critical to keep that in mind and really continue to fight that war. And next slide, that's it.
Yes, thank you very much. And I just, for that great presentation. And if people have any questions after hearing all of that, you can type them into us, and we have moderators ready to answer your questions. Malinda, are there any questions that come through that we want to address now about the previous portion of our webinar?
Sure. Thank you so much, Nina. We really appreciate all this great information. I'm wondering if you could explain, so does this mean that women who are employed in those closely held corporations aren't going to be able to get birth control, or can you explain again what that really means for them?
So the women working for these closely held corporations, it doesn't mean that they're not going to have access whatsoever to contraceptives. Really what it means is that these closely held corporations can now fill out a similar form that religious nonprofits fill out, and this form just certifies, I have these genuinely held religious beliefs and I conscientiously object to providing contraceptives, and you fill out and you provide that to the insurer or the third-party administrator, and then the insurer or the third-party administrator themselves must provide contraceptive coverage to the female employees who want this.
That's really helpful. Thank you. And could you go back? There's a question about, you mentioned that the Hobby Lobby ruling contradicts a ruling of the Equal Employment Commission from the 1990s. Yes. Can you talk about that again?
Yes. So this was a ruling. It happened in the year 2000. So the Equal Employment Commission, they're a federal agency, and they had an administrative hearing and ruling. And they ruled that according to another federal statute, the 1978 Pregnancy Discrimination Act, health plans that explicitly do not cover contraceptives and other contraceptive counseling, sterilization procedures, those that do not cover those services are discriminatory under the 1978 Pregnancy Discrimination Act.
So basically what you're saying is that in this case the court chose to sort of balance that against the religious rights of these employers. Is that right?
Right, exactly.
And so one question was, if an employer, excuse me, I know that we have a train in the background, but if you can hear me, if an employer-sponsored healthcare plan does not cover contraception, can the woman obtain services from a Title X family planning clinic?
You know what, Malinda, do you have input on that? I know you're really familiar, very familiar, with many years' experience on Title X.
Sure. So the answer to that is it does depend. I would say absolutely go to the clinic, and you should be able to have access. Sometimes it depends on your income, but absolutely there's nothing that would prevent that woman, if she's otherwise eligible for Title X services, to going to those clinics and obtaining services there. And absolutely, again, this is not saying that we're limiting access for women through Title X or other currently available programs. This is just about a specific kind of employer seeking an accommodation. So I would definitely encourage you to go check out Title X, which of course is the money that comes from the federal government that funds access to family planning services. And so check out those organizations like Planned Parenthood and others in your community if you're having trouble accessing birth control or other services.
So, great. Are there any other questions, Malinda, that we want to take at this time, or go on to our next portion?
So one question was to kind of explain one last time about what you meant as far as the accommodation. How does the third-party payer paying for the birth control differ otherwise, since for most women they have access to birth control by having it covered by their health plan. So if you work for Hobby Lobby and they have filed an accommodation, you know, how is it really that different?
Well, actually, that's a very good point to bring up, because Justice Ginsburg, who actually wrote the dissent in the Hobby Lobby opinion, she points this out immediately. She says, what is the difference between Hobby Lobby stores providing this coverage through their health plan, or you know, the employees just taking their wage that they receive from Hobby Lobby and going out of their way to a family planning clinic, to Planned Parenthood, and buying contraceptives there. It's really no difference whatsoever. It's just really the employers in their religious views and beliefs feel very conscientiously opposed to them personally facilitating the contraceptive coverage. But I'm assuming that, you know, if the employees take their own wages and use it for contraceptives, or if a third-party administrator or the insurer provides the contraceptive coverage, it's more of an attenuated relationship, and then the employers feel more comfortable with that.
And yeah, and I would just say two things to clarify. I think one is on a kind of practical side. Once that certification has been made, there is an obligation on the third-party administrator and the insurer to reach out to the insured from that corporation or from the organization that certified the exception to advertise that this service is available and to provide it. So in some ways, those women, to the extent that they're just have always been receiving this services or FDA services as far as contraception goes from their insurer, it shouldn't necessarily impact that, as you mentioned. And then I think the other thing to point out is, again, this idea of the accommodation is something that we are concerned about moving forward. I know that Nina mentioned a decision that the Supreme Court handed down in a case called Wheaton, where Wheaton College was objecting to the accommodation itself for some of the reasons that Nina mentioned, that by just certifying that they object and having to say that to an insurer, they're somehow complicit in the insurer itself providing the service. So we don't have an answer yet on whether the accommodation itself will be upheld as constitutional or not. For now, it is constitutional for everybody but Wheaton College. And it's important to understand that even if that accommodation falls, it's likely that there will be other accommodations that will be talked about and looked at. So very important to follow along. And I think the last question that keeps coming up here is that what is the impact of this on other kinds of anti-discrimination concerns that we may have about the LGBT population, about individuals living with HIV? And I think there's two things to think about as far as that goes. One is to say, yes, on the one hand, it does raise some concerns, particularly around if they're, if closely held corporations can raise religious objections to government mandates. It is certainly of concern to us as advocates for many other kinds of minority and vulnerable populations. At the same time, I think we have to, for now, take the court at its word that this is a very narrow ruling, or at least they attempt to make it a very narrow ruling. And those I have not seen yet, the others have, but I have not seen yet any attempts in light of Hobby Lobby to try to go further in addressing other kinds of anti-discrimination mandates. And I think we need to be very clear as advocates that Hobby Lobby does not impact those anti-discrimination mandates as far as we're concerned. So I think that's important to know. So Sarah, I think that's about it as far as questions. And then if there are any ones that come up, we can also turn again to additional questions after we hear the next part of our presentation.
Perfect. Great. Thank you, Malinda. And also thank you, Nina, for that great presentation. Like I said, and people can keep the questions coming, and we'll have further opportunities to answer those. But for right now, we're going to move on to our next speaker, Spencer, who'll be going over the Halbig and King cases. Malinda, you're going to introduce that a little bit?
I think Robert covered that, and I turned over to you, Spencer.
Hi, everyone. As Sarah mentioned, my name is Spencer Benge, and I will be covering the most recent decisions or challenges to the ACA, which come in the form of the Halbig and King decisions. And I'm just going to go through some background to give you some context for the case, because there's a lot of moving parts that are going on, and then we'll get into the cases themselves. Next slide. So to start out, the ACA has created these marketplaces, and they're also called exchanges. Exchanges was the original term for them, and the administration decided to switch to marketplaces, but the language is still a little inconsistent in the courts. So what these are, they're online portals that the ACA has created through which people can purchase health insurance plans. And they have three main goals. One, to increase accessibility to health insurance, so to be kind of a one-stop shop for purchasing insurance. Two, to increase the comparability between plans so that people can just put two plans side by side and see which one is better. And three, to provide a means and a framework for regulation. And so also important to know about these marketplaces is that there are three different types. And we have state-run marketplaces, which are when an individual state will decide to establish and operate its own exchange. And then you have the federally facilitated exchanges, which when a state refuses to establish its own exchange, the federal government steps in, establishes and operates an exchange for that state. And then you have this sort of hybrid group with the state-federal partnership where the state and federal governments share responsibilities that they can negotiate between themselves. Next slide. So we currently have 16 states that have elected to establish their own exchanges. We have 6 state-federal partnerships, and then the rest of the states are federally facilitated. Next slide. And just to start out with some background on the individual mandate, because it is important here, the ACA's individual mandate requires that all individuals with incomes above 100% of the federal poverty level either have to purchase health coverage or pay a tax penalty. But then there's this unaffordability, or sometimes the affordability exemption, which says that if the cost of insurance minus any premium tax credits that an individual would receive is over 8% of that individual's income, the person is exempt from paying the tax penalty. And so the individual mandate is really a critical part of the ACA because it keeps insurance rates down and affordable, and counterbalances what would normally be an increase in premiums because of the pre-existing condition exclusions. So it's really key to the ACA. And it was upheld as a constitutional tax in the National Federation of Independent Business v. Sebelius case, which is commonly referred to as an FIB. And you might have heard about it. There was a lot of buzz about it when it came out. It was also the decision that made the Medicaid expansion optional. And so the bottom line here is that a minority of people really were upset with the individual mandate and didn't like it. Next slide. And so moving on to some background about the premium tax credits, which are really the main focus of these two cases. The premium tax credits subsidize individuals' insurance premiums that are low or middle income families and who buy insurance through marketplaces. Now the ACA has a lot of provisions that have these tax credits in it, but in these two cases, one provision is at issue here. And so it's the provision that calculates the annual premium tax credit amount by adding up that amount from each coverage month. And it defines a coverage month as one in which an individual was enrolled in a health plan through an exchange that was established by the state. And that's really the key language of these two cases, is established by the state. And so what the IRS did after that was they created a rule that allowed for these premium tax credits in either state-run or federally facilitated marketplace. So it allowed for these tax credits in both types of marketplaces. Next slide. So the issues here, what the courts were decided to ask was whether the IRS had exceeded its authority that was given to it by the ACA when it created its rule that allowed for these tax credits in both types of marketplaces. So in other words, the question here is whether the ACA limits the availability of these tax credits only to state-run exchanges, excluding the federally facilitated exchanges. Next slide. And so the plaintiffs in these two cases are very similar. So rather than go through each one separately. I'm going to lump them together. They are individuals that are residing in states with federally facilitated marketplaces who qualify for these tax credits under the IRS rule as it is currently in effect. And so without the availability of these tax credits, the plaintiffs would qualify for the affordability exemption. But if they were to receive the tax credits, their cost of insurance would drop such that they would not qualify for this exemption. And so the plaintiffs, they didn't want to buy insurance, they didn't want to pay the penalty, and they wanted this exemption. So what they did was allege that the plain language of the ACA only allows the IRS to provide for these tax credits in state-run marketplaces and not in federally facilitated marketplaces. So they were trying to get the tax credits out of the marketplaces they were in so they could qualify for the exemption. Next slide. So more specifically, the plaintiff's arguments were that this particular section of the ACA should be interpreted literally, that the tax credits for individuals are calculated based on the cost of a qualified health plan enrolled in through an exchange established by the state, and that this provision only refers to marketplaces that are established by the state, and it's not referring to federally facilitated marketplaces. And so this is kind of how they base their argument around getting these tax credits out of federally facilitated marketplaces. Next slide. So the government counters with their arguments that the provision the plaintiffs referred to read in context of other provisions of the ACA actually do provide for these tax credits in federally facilitated marketplaces. And the first section they look to is the section that talks about when a state refuses to set up its own exchange, the federal government comes in and establishes such exchange for that state. And what the government argued was that this language, such exchange, meant that the federal government stepped into the shoes of the state and established that marketplace on the state's behalf. And so that really the federally facilitated marketplaces are ones that are established by the state for the purposes of these tax credits. And the government also, secondly, pointed to another provision that requires these federally facilitated marketplaces to report annually the amount of premium tax credits that are going through that marketplace. And the government argued that this would be superfluous and nonsensical if there were no tax credits for the federally facilitated exchanges to report. Next slide. Next slide. Okay, so part one of how the courts go about figuring all this out is that they look at the plain meaning of the statute to determine if the agency, which in this case is the IRS, created a rule that was a valid exercise of the authority that the ACA gave to it. And so what they do is they look at the statute and try to determine if it's clear and unambiguous. And if it is, then that means that the congressional intent has been shown and that the agency, the IRS rule, must strictly follow that intent. But if the court decides that the statute is ambiguous, then they cannot say that Congress's intent has been shown. And so they have to give deference to the agency's interpretation of the law as long as it is a permissible construction of the statute. So as long as the rule is a reasonable interpretation of what the statute could mean. Next slide. So on to what each court actually decided. The Halbig court decided that the section at issue here was clear and unambiguous, that tax credits are available for individuals who purchase their plans through marketplaces established by the state, and that federally facilitated marketplaces are not in fact established by the state. And that if Congress meant to refer to both exchanges, it would have just said something like enrolled in an exchange without specifying that it was one established by the state. Then the court also looked at legislative history and determined that it was lacking and there wasn't much to dissuade it from its position. Oh, and I also wanted to add that on the second government argument, about the reporting requirements for the federal exchanges. The court very briefly dismissed that argument and just said that, yes, it would be over-inclusive, but that over-inclusion is often tolerated in the law. And it didn't really give a great explanation of how that would still make sense in light of an interpretation with only state-run exchanges. Next slide, please. On the other hand, the King Court took what I found to be a more objective interpretation of this and saw reason and saw merit in both arguments, both the literal reading of the plaintiffs as well as the contextual reading of the government. And because there were two reasonable arguments here, it decided that the statute was ambiguous. So it, according to the precedent, deferred to the IRS interpretation that tax credits should be available in either type of marketplace. And it decided that the IRS was a reasonable interpretation of the statute and that it was in line with the overall purpose and the broad goals of the ACA. And so it upheld the rule. Next case, please. Or next slide. And so the bottom line here, the takeaway from each of these is that the Halbig Court found the plain meaning of the ACA only to permit tax credits in exchanges established by the state. And the King Court upheld the IRS rule because it found that the ACA statute was susceptible to multiple interpretations. There were multiple reasonable arguments that could be made, and so it upheld the IRS rule. Next slide. And so just how this is going to work as far as our federal court system, we had the district court decision, and then the Halbig case was appealed to this three-judge circuit court panel in the D.C. Circuit, and that was what just came out. So now we have above that the en banc circuit court panel, which is basically the D.C. Circuit actually has 11 judges, even though the decision that was rendered was only decided by 3. So the en banc appeal will be decided by all 11 judges. And that's what's possibly next for the Halbig case. The King case was actually heard by the entire Fourth Circuit, so the only next step for it would be to appeal to the Supreme Court. Next slide. So going forward, the Halbig decision, like I said, will likely be heard by the full D.C. Circuit Court on the en banc appeal. And the Supreme Court here, they could choose to hear the King case right away, but it's more likely that they're going to wait for the Halbig appeal to see if there's still a circuit split. So if the Halbig decision is overturned and both of the courts are agreeing on this issue, they're a lot less likely to hear an appeal. But if the Halbig decision is upheld and there still is a difference between the two courts, the Supreme Court's more likely to hear the case. Next slide, please. So what can we do in the meantime? For right now, for the 2014 tax credits, they are safe and they're not going to change. But the decisions will be coming around within the next year, and the open enrollment season is coming up. So what we can do now is just try to get the word out, try to make your voice heard, talk to your state and federal legislators to let them know how important this issue is to you. Try to collect stories of how these tax credits have really helped people be able to afford the insurance that they're trying to obtain, and try to educate people in your state about how important these premium tax credits are and what's really at stake here. I mean, because there really is a lot at stake, and this is especially important for all of you in states with the federally facilitated marketplaces. And last slide, please. And so there are just some resources here for you to go to research this issue more and the issue that Nina talked about on here and other health issues. And thank you all for listening.
Thank you so much for taking us through that. That was very complicated, but I think that broke it down in a really great way. And thank you again for having these resources posted. Just to let everyone know, too, these are posted on the HIV Health Reform blog, so people can go there and check out these links. Malinda, are there any questions that we want to take at this point?
Definitely. So one question was, how easy would it just be to, rewrite the rules on premium tax credits? Why can't we just go back and change that particular section of the ACA and just make it so that everybody understands exactly what it means?
Well, that obviously is possible through our congressional laws, but the problem now is just the gridlock in Congress. It would be very hard to get something passed that would help the ACA when there have been, mainly by Republicans, the 47 attempts, 49 attempts, whatever it is, to repeal this Affordable Care Act. So it's really unlikely that any legislation will get through the House to help the ACA.
And so how does something like this happen? Why does Congress in some way create ambiguity like this, or how does this occur?
Actually, the King Court actually mentioned this in the opinion, and it talks about how obviously the ACA is 900 pages long. It's very complex, and a lot of times Congress legislates in parts, so they're not just going through the law all at once, all together. It's coming from different groups at different times, and so the court recognizes that this is actually a pretty common thing to have a little bit of ambiguity in some of the inconsistencies in some of the languages in such a huge and complex bill.
And does, as far as you know, was this a ruling about cost sharing or just about the premiums?
As far as I know, this is just about the premiums.
Right. And so one question that has come up is as far as the 2014 tax credits, you mentioned, or Spencer mentioned, that the 2014 tax credits are not yet at issue. And I think we do need to say, just so that folks are aware, there was a request. So when we were talking about what happens next, right, we talked about, well, the Fourth Circuit, the King case, they could request an en banc decision, but they haven't. They've decided to go directly to the Supreme Court, so not D.C., but this King case. And they, in that case, unfortunately, the plaintiffs have asked the Supreme Court again to find that the ACA does not allow tax credits in federally facilitated exchanges. And they have mentioned something to the effect of wanting to what's called claw back some of those 2014 tax credits. Now, we think that that's very, very unlikely. So as far as we know, those tax credits are safe. It's not clear what the impact would be on the 2015 tax credits yet, although we hope and feel strongly that this decision should be interpreted in the way that King has decided, which is that those this section needs to be interpreted in context of the larger ACA. And certainly we all know, as Spencer explained, what a cornerstone of the law the availability of these tax credits are. And so one other question that has come up is what should Ryan White providers do in this context? How can we plan? What can we do to prepare? And I think, unfortunately, in light of what I said, it's hard to say that Ryan White needs to change its entire adjustment to the ACA because of the uncertainty in the tax credits. I think the reality is we have to sort of sit and wait a little bit as far as the Supreme Court goes. I don't think there's cause at this point to be telling people to be concerned about the availability of their premiums. I think we have to sort of move forward, but do so vigilantly, keeping aware of what's happening within the courts, because it could eventually affect us. But I think for right now, we really need to, again, as Spencer said, make sure we're telling everybody that we know, legislators, agency officials, how important these premium tax credits are. Now, I know you all have heard me on webinars before where I talk about anti-discrimination provisions and my concerns about some of the qualified health plans, but it is equally important, very important, that we share stories of positive experiences with the marketplace, and again, how critical access to those tax credits are. And I think that's one of the biggest ways we as advocates and Ryan White programs and others, one of the biggest contributions we can make as this issue makes its way through the courts. So Spencer, somebody else asked if there's an opportunity for amici briefs. Is that helpful, or can you talk about what that means?
Actually, Linda, do you have anything to say on that? I think you might be better suited to answer that one.
Sure. So I think the answer is, once we have an idea of what the next step in the process will be for each of these cases, then yes, there will definitely be a desire and a necessity of filing amici briefs. And what that means is that when you have decisions at this level talking about various issues, the court can accept what are called amici briefs, and what that really means is it's something called friend of the court. And so they're really looking for some information on aspects of the case from a policy perspective or other perspectives to indicate, to give them additional information that's important about deciding the case. And again, really looking towards some of the policy implications here. And I think in this case, we certainly will be working with our partners to try to file an amici brief and to make sure that the court understands the implications of a decision like this as far as taking away tax credits. And certainly our friends at the National Health Law Program, other National Women's Law Center and Hobby Lobby, there are a lot of groups who are very watching this very closely and looking to file amici briefs as well to, again, explain what the impact of a ruling like this could mean for the people and the groups that we work with. And those are a critical part of the court process as it proceeds. So let's see. I don't think we have any other questions. Well, let me just look down here.
Yes, and if people do have questions, we do have a little bit more time, I believe. Is that right, Malinda? If people wanted to type in some questions right now.
Definitely. So one question we have that just came through is, how does this affect the Medicaid expansion in states?
As far as I'm aware, and Malinda, you might be able to speak to this better than I can. I know you're more well-versed in Medicaid. I didn't know of any implication that this had directly on Medicaid. The courts hadn't talked about it. Malinda, do you have something there?
No, I think that that's exactly right. So this doesn't have any implications for Medicaid expansion. As we talked about, the decision, at the very beginning, kind of the seminal decision that dealt with the ACA, which was a few years back now, which was the National Federation of Independent Businesses, did kind of have a whole group of complaints, one of which was the Medicaid expansion, which we all know now became optional, and another part of that case was the validity of the mandate itself. So these particular cases are only looking at the premium tax credit issue. They don't have anything to do with Medicaid expansion. But I'll just use this opportunity to say that, again, Medicaid expansion continues to be very, very important. And lo and behold, if you look at some of the states where they have not chosen to enact their own exchanges and are instead using federally facilitated exchanges, many of those states are also states where they have not enacted a Medicaid expansion. And if worse came to worse, and again, there was to be some sort of interference with the availability of premium tax credits in those states, again, having Medicaid for the lowest income individuals becomes even more critical. But again, these particular cases do not have an impact on Medicaid.
Great, thank you for that clarification. And I'll let Malinda look over the questions that are coming in just one more time. But I also just wanted to remind people that if there's a question that wasn't answered, we have a log of all of these, so we will be collecting all of these. And if there's something we didn't get to today, we'll be able to email people out their answers. This webinar is being recorded, so we're going to make this recording available on HIV Health Reform this week, as well as all of the resources that all of our great presenters have gathered for us at the end of these slides. We'll make those available as links on our blog as well.
So there's one question that came through relating back to the Hobby Lobby decision. So Nina, I don't know if you can jump in again. The question was, what if somebody needs birth control for other medical reasons besides just birth control? So for example, there may be another medical reason why some sort of contraceptive is necessary. How does this impact that, or how does the religious accommodation impact that particular issue?
Well, honestly, the religious accommodation, it covers religious nonprofits that just have a blanket objection to contraceptives in general. So it's not really taking into consideration many women, such as myself, who do have to take birth control because of other medical reasons, which is something that's, that we want to stress, that Justice Ginsburg really stressed in her dissent, is that this is concerning personal medical decisions, that women are making with their medical providers. And so this religious accommodation, if it's extended to, closely held corporations, which comprise 9 out of 10 businesses within the U.S., I think that can really substantially affect. I mean, we don't know what the accommodation yet, like we said, is going to look like in the future. The federal government is going to release regulations that we should all comment on, but unfortunately, I mean, if the accommodation looks exactly like the one for religious nonprofits, then women, no matter how, why they need the birth control, they will be able to get it through the employer's insurer or third-party administrator. But now, like we said, with the Wheaton case, we don't know what the Supreme Court is leaning towards with this exemption in the first place. We don't know if they're going to rule if it's valid or not. So we're waiting for that to see what impact this really is going to have, which potentially, it could be great.
I think that's really helpful. So as far as, the different reasons that women need birth control, there are obviously a variety of reasons, some of which that have nothing to do with pregnancy prevention, which is a really critical point, and I think one of which speaks to the importance of the government's purpose in ensuring access to these kinds of medical prescriptions and medications and contraception. And I think that it is important, as Nina said, to recognize that the accommodation is based on a religious objection to taking those pills for any reason, or those kinds of medications or contraceptions for any reason. So it doesn't necessarily matter to the person who's certifying the objection why you're seeking that particular type of birth control for purposes of the objection. But again, I want to stress that you kind of have two options there. One is to say, again, you should have access to birth control through your third-party administrator or insurer if your employer is seeking the accommodation. And two, if there is something that you need that you've been denied, which you think is medically necessary, you always have the right to appeal through your insurance company. So that's sort of a separate issue, but I do want to make sure we keep that in mind and not separate and not confuse the two. And then there was a question about what can individuals do in state-based marketplaces to help those in federally facilitated marketplaces who are concerned or want to weigh in and are worried about our community members in states where they do have federally facilitated exchanges. And I think the answer there is very similar to what we need in the federally facilitated exchanges, which is to continue to put out publicity, stories, explanations of why, again, access to those premium tax credits is so critical and what a positive difference that has made. And certainly we've seen in Medicaid expansion, there's now a disparity between those without the Medicaid expansion and those with the Medicaid expansion. And it is really critical that we all fight to make sure that such a disparity would not happen as far as the outcome of these cases are concerned. So for those of you in state-based marketplaces, I think, again, talking about how important it is to have these tax credits is really important. And I think something to keep in mind as well is that in the event, which we think is unlikely, but in the event that these tax credits, the court somehow ruled that the tax credits were only available in state-based marketplaces, that could have a really devastating effect kind of on the insurance industry as a whole, because as Spencer mentioned, the mandate and the need to have health insurance is a really, mandate and requirement to have health insurance is a really critical component of how we keep costs down in light of all the anti-discrimination mandates, like the requirement to cover people with pre-existing conditions, et cetera. So having that kind of knocking down that pin in the sort of whole schemata of the ACA would be, I think, have a very detrimental effect on the insurance industry as a whole. And so we want to make sure, again, in state-based marketplaces that we are weighing in with how important it is that those premium tax credits be available in every state. So, Sarah, I don't think that there are, well, I'm scrolling through here to see what other kinds of questions we have. The one question was, would the state-based marketplaces continue to have the tax credits if those in federally facilitated marketplaces went away, or if the court ruled that those tax credits were not available? I think, we want to just be careful not to fall too far down the rabbit hole as far as speculating what would or would not happen. I think that the reality is technically the law would not impact those in state-based exchanges if it were to say that the tax credits aren't available in federally facilitated exchanges. So I think, keep that in mind, but at the same time, it is such a cornerstone of the law that, as I was discussing, that it seems like there would need to be some additional changes should the court rule on that particular issue and saying that the tax credits would not be available.
Great. Thanks, Malinda.
Sure.
Does it seem like we have worked our way through most of the questions?
I think we have. There was another question, and we'll just kind of tie it up with this. Again, there was a question about how does the ruling in Hobby Lobby potentially affect individuals living with HIV/AIDS, and again, I'll extrapolate from that to say kind of other vulnerable communities that we've worked really hard to protect with the anti-discrimination statutes. And again, just to reiterate there, I think we need to hold the Supreme Court to its word in saying that the impact of the Hobby Lobby decision is only about contraception, and it only says that these particular closely held corporations can request an accommodation. And I think that we as advocates need to be very vigilant in explaining to anyone who will listen and explaining in any kinds of context that we're in that there are still very clear anti-discrimination mandates in place. And I know some of you asked questions about sort of drug tiering and pricing, which we're not talking about on this particular webinar. But again, I think we need to be very vigilant in enforcing the other anti-discrimination mandates that exist, and keep in mind that this case, we think for now, should not impact that. But do we know for sure? No, I think we are concerned about whether an employer now could say, under the Religious Restoration Act, whether they could object to another part of the ACA based on religion. So again, for now, we need to work vigilantly to uphold the existing non-discrimination mandates. And I'll just take a moment here to plug our Speak Up project, which is also available through HIVhealthreform.org. So if you are starting to see additional instances of discrimination based on Hobby Lobby, or just sort of your general concerns about pricing and other issues related to the ACA implementation, please do write to us at Speak Up. That is the sort of vehicle that we use to kind of track some of these issues on the other side. So again, please do plug into Speak Up if you haven't already, and let us know what you're seeing on the ground.
Yes, thank you for that, Malinda. And again, that's just at hivhealthreform.org /speakup. And we would love to hear from you on any of those issues that Malinda just mentioned. Excuse me. Yeah, and I just want to thank everyone for participating and listening in today. I just wanted to also, just a couple of housekeeping things, let you know that, again, this is being recorded. We will make it available and send you all an email with the recording and the slides, in addition to the resources mentioned by our presenters. Also, we have a there's like a follow-up, post-webinar follow-up survey afterwards. So after you send out the webinar, if you could please take a couple minutes to fill that out and give us any feedback that you have or any lingering questions. That way we'll be able to just make sure that future webinars keep getting better and better, and that we're actually answering the questions that you have. And yeah, and just go to hivhealthreform.org and stay tuned, as I said, for future webinars and for the resources from this webinar. And I also wanted to say thank you again to our great presenters who joined us today for kind of taking us through all this information. It's very complicated, but they laid it out in a very clear way. So again, that was Robert, Nina, Spencer, and Malinda. Thank you so much. Any closing thoughts, Malinda, or any of the other presenters?
Nope, I want to thank our students. We really appreciate all of their hard work this summer. For those of you who don't know, our students' summer program ended a few weeks ago, so they are very generous in continuing to volunteer their time with us for this purpose. We really appreciate it. Again, I can't iterate enough how critical it is to hear from you, so please do indicate in the webinar what you thought, what else we could do to be helpful, and please contact us through Speak Up to let us know what you're seeing as far as ACA implementation in the communities that you work in. So thank you so much. We really appreciate your participation today.
Thanks, Nina and Spencer. You did an awesome job.
Thank you. Thanks, everyone, for tuning in.
Thank you, everyone. Have a great afternoon. Bye-bye.